Well, hello everyone, and welcome to Level Up Law, where we here at South Carolina Legal Services are providing webinars in our law practice areas to help you improve not only your basic legal knowledge, but also your ability to help yourself if you don't have a lawyer. I'm Susan Ingalls, and I'll be the moderator today. Today, our speaker is Employment Law Unit Head for South Carolina Legal Services, Stephanie Horst. And she will be leveling up your knowledge on navigating unemployment benefits during COVID-19. I want to mention that you can feel free to pose general questions about the subject throughout the webinar in the question box, and Stephanie will be glad to answer as many of those as she can. We obviously can't give legal advice on the webinar, but we can try to answer some general questions. All registrants will receive the PowerPoint slides and a recording of today's webinar by email. And at this time, I will welcome Stephanie Horst, our Employment Law Unit Head. Stephanie, thanks you for being here, and here we go.
Thanks, Susie. So today we'll talk about navigating unemployment benefits during COVID-19. I will start with just an overview of regular unemployment benefits, and then we'll get into some special provisions that are in action right now because of the pandemic. So I'm with South Carolina Legal Services. I am the Employment Law Unit Head, and South Carolina Legal Services is a statewide nonprofit law firm. We provide free civil legal services to individuals and households that are under 200% of the federal poverty guidelines. You can apply for our services by calling our intake office at this number, or you can apply online at the link provided in the PowerPoint. Okay, so unemployment insurance arose during basically the Great Depression because of economic insecurity during that time, and to provide some sort of stipend for individuals that found themselves without work and employment so that they could maintain their home and they could buy food and things like that. So that was the purpose of unemployment insurance benefits, and we've had some serious crises such as the Great Depression since then, and of course we are in one right now due to COVID-19. So unemployment insurance is a joint state and federal program that provides cash benefits to eligible workers. Each state administers its own program according to the federal guidelines. The amount of your unemployment insurance benefits is based upon the wages that you have earned in the last 4 quarters, the first 4 of the last 5 quarters you worked. So for instance, the way that works is if you become unemployed between, let's say, January and the end of February in 2020, then your unemployment weekly benefit amount would be based on the quarters from 2018 and 2019, with the last quarter ending December 31st, 2019. It's a little cumbersome and a bit confusing, but that's what it is. You are eligible to receive a maximum number of 20 weeks of benefits for a maximum benefit amount of $326 a week, and then a total benefit amount, that's all 20 weeks, it's $65.20. Okay, so in order to be eligible for unemployment insurance, you have to be able, available for, and actively seeking work. You are required to file weekly claims by telephone or on the website. You're certifying each week that you are able, available for, and actively seeking work. You're supposed to be engaging in work-seeking activity, which includes 2 work searches through the department's website, and claimants must wait 1 week after separation from employment to be eligible for benefits. Now, currently, the work searches and the 1 week waiting period has been waived for claims that have been filed between March 15th and April 18th. However, claims filed before March 15th and claims filed after April 18th are both still required. Claimants who file those claims before that date and after that date are still required to perform work searches, and you have to wait a week before you can receive benefits. Now, the best way to apply for unemployment benefits right now is online through the Department of Employment and Workforce's website at www.dew.sc.gov. You can do that using a computer or a smartphone. You can also, if you don't have access to a computer, you don't have a smartphone with internet access, you can file a claim over the phone with TeleClaim at 1-866-831-1724 between 8 a.m. and 4 p.m. on weekdays. So due to COVID-19, the Department of Employment and Workforce is experiencing an extremely high volume of calls. It's very hard to get through. I'm hearing testimony from claimants that it's taking them hours to get somebody on the phone. They're on hold for 2 to 4 hours. So the best way to communicate with the department right now is really online, and it's during non-peak hours. So even their online system is overloaded at some points during the day. So what I've been advising individuals is to either try and log in prior to 8 a.m., after 5 p.m., or during lunch between 12 and 2 p.m. That seems to be the best hours to check out your claims, see what's going on, and then also to access documents. Work centers are still mostly closed because of COVID-19. You can check on the status of the work center closest to you at scworks.org, and then there's an icon that you can click on for information about statewide centers. Okay, when should you apply for unemployment insurance benefits? So you should apply as soon as your employment circumstances change. So that means as soon as you are terminated, as soon as your hours are reduced, as soon as you're laid off. You should still apply even if your employer tells you not to apply, if your employer is still open, or if your work hours were reduced, because you can, in some circumstances, qualify for unemployment insurance even if you are still working part-time. So you can earn up to 25% of your weekly benefit amount. So if you're earning without receiving a reduction in payment. So if your weekly benefit amount is $326, you can earn up to 25% of that, which is about $70, without the department reducing your weekly claim. I know it's not very much. If you're making $10 an hour, you can basically work approximately 10 hours a week, or 7 hours a week. Okay, so the earlier you apply, the earlier you can begin to receive benefits. So while it may take some time for your claim to be processed and approved, you will be paid retroactively back to the date that you applied for benefits. I know that some individuals have had trouble logging on to even apply for benefits, and the department has established a committee to review those complaints to see if benefits can be applied retroactively to prior to the date that you applied. So if you were laid off, let's say March 22nd, but you tried to apply for benefits for 2 weeks and you weren't able to apply until, let's say, April 4th, you can notify the department that you had that issue, and they will review your claim to see if you can get benefits back to the date of your separation. So generally, there is a 1-week waiting period before you can receive benefits. However, as I stated previously, that waiting week has been waived by executive order due to COVID-19. I will say that that waiting week is only waived for claims that are filed between March 15th and April 18th. Okay, so what do you need to know about regular unemployment insurance benefits during COVID-19? So you're eligible for benefits if your employer ceased operations, you were laid off, or your hours were reduced, even if you were not formally separated from employment. So if your employer is giving you 0 hours a week to work, but you're not officially terminated, you're still eligible for unemployment because you're not making any income. General benefit guidelines still apply. That means that the maximum UI benefit that you can receive is $326 a week. The maximum number of weeks is 20 weeks, and the maximum benefit amount is $65.20. And as I said, based on guidance issued by the U.S. Department of Labor, the 1-week waiting period and work search requirements have been waived for claims filed between March 15th and April 18th. So there's been some information out there about whether or not your employer's unemployment insurance benefits account will be charged based on your claim for unemployment. So because COVID-19 has created a state of emergency, and the reason that you are either your hours are reduced or you're laid off or you're terminated is not the result of your employer's misconduct, their account will not be charged for your unemployment insurance benefits. So employers pay in on a regular basis into a fund that is managed by the Department of Employment and Workforce to pay unemployment insurance benefits when an employer terminates an employee without cause. Usually if you apply and you are awarded unemployment insurance benefits, your benefits come out of this employer's fund. But because of the nature of the pandemic, because it is an emergency and it is the governor has issued a state of emergency, your employer is not responsible for paying your unemployment insurance benefits. Okay, so that is regular unemployment insurance benefits. There are some additional benefits that are available right now because of COVID-19 and the CARES Act, which is the Coronavirus Aid, Relief, and Economic Security Act. So this law addresses the economic devastation caused by the coronavirus pandemic, and it expands eligibility for unemployment insurance benefits, increase the amount of benefits you can receive, and extends the number of weeks that you can receive benefits. Okay, so the first program is Federal Pandemic Unemployment Compensation, FPUC. So the federal government is providing an additional $600 per week to any worker eligible to receive state or federal unemployment insurance benefits. So what that means is, in addition to your maximum benefit of $326 per week, you are also eligible to receive $600. So the maximum benefit amount an individual can receive is $926 in total benefits. So that funding is available between April 4th through July 25th. And the Department of Employment and Workforce began paying out FPUC on April 12th. Okay, the second program is Pandemic Unemployment Assistance, PUA. So PUA provides compensations for individuals that are ineligible to receive regular unemployment insurance benefits. In order to receive UI benefits, you have to be an employee of a business. So that means certain individuals are excluded automatically. Those are independent contractors, individuals who file a 1099, those who are self-employed, church employees, and gig economy workers. So gig economy workers are individuals that work in temporary technical jobs, such as, for example, like Lyft or Uber or DoorDash, things like that. So claimants are eligible for weekly benefit amount calculated under regular state unemployment insurance law, plus the $600 from the FPUC. So that means that the Department of Employment and Workforce reviews your wages for the last 4 out of the 5 quarters completed, just like they would under a regular UI claim, and then determines the amount that you're eligible for. Now, in addition to that regular weekly benefit, the max of which would be $326, you will also receive $600 in FPUC. So the application for PUA was implemented by the Department of Employment and Workforce on Friday, April 24th, 2019. So if you applied for regular unemployment insurance benefits and were found ineligible, you would have received notification to apply for PUA. And it would have popped up under your claimant portal as well. Okay, so to be eligible for PUA, you must have been determined to be ineligible for unemployment insurance benefits, that's regular UI, and meet one of the other conditions. You've been diagnosed with, or a member of your family has been diagnosed with, or you're providing care to a household or family member or child who is unable to attend school or their adult daycare because of COVID-19. You are unable to reach your place of employment because of a quarantine imposed as a result of COVID-19. You're unable to reach the place of employment because the individual has been advised by a healthcare provider to self-quarantine. So if you have an underlying condition that makes you more susceptible to COVID-19 and you've been advised by a physician to self-quarantine, then you would be eligible for PUA, even though you wouldn't be eligible for UI, because that would mean that you weren't able and available to work, which makes you ineligible for UI. You were scheduled to start work, but your job offer was revoked because of COVID-19. You have become the breadwinner or major support for a household because the head of household has passed away as a result of COVID-19. You had to quit your job because of COVID-19, or your place of employment has closed because of COVID-19. Okay, so the last program implemented under the CARES Act is the Pandemic Emergency Unemployment Compensation Program, which is PEUC. And what this does is provides an additional 13 weeks of benefits to individuals who exhausted their standard unemployment insurance benefits, 20 weeks. So if you've already collected 20 weeks of benefits, then you can be eligible for an additional 13 weeks under PEUC. You have to exhaust state benefits, or your benefit year has ended and you have not qualified for a new benefit year. And you're eligible for the weekly benefit amount from the previous year plus $600 FPUC payment. So you would get what you were receiving under your UI benefits for that 20 weeks, and then you would also get the $600 additional payment under FPUC until July 25th. I'm just going to go back real quick. So this was just implemented 2 weeks ago. Now claimants are receiving notification that the program is in full effect and that they would be eligible if they're eligible under regular UI. If you previously exhausted your benefits, there's an application procedure that you need to follow as well. So it should pop up similar to what PUA did in April. It should pop up with an option for you to apply for PEUC. Okay, so this is a quick reference chart for unemployment benefits during COVID-19. It goes through regular unemployment insurance and then through the additional programs provided under the CARES Act. And also provides the eligibility requirements and your monetary eligibility requirements as well.
Stephanie, this might be a good time to check in with the questions. We do have one question about the UI benefits right now. And that is, what do I do if I'm denied UI benefits due to being terminated unfairly?
Okay, so if you were denied UI benefits, but you didn't do anything wrong to cause your termination, then you need to appeal. The appeals process is interesting, so I'm just going to skip to the appeal slide. Basically, when you receive your determination letter, it has a mailing date on it. You have 10 days from that mailing date to request an appeal. So it's a very quick process. You can request an appeal by logging into your claimant portal. And there's a button that says request appeal. The Department of Employment and Workforce also provides a form called a notice of appeal that you can submit. Or you can simply write a letter saying, I want to appeal my denial of benefits because of this reason. I was not terminated for cause, and basically explain what happened. You can then, I would recommend doing several things if you have the ability to do so. Number one, you should upload your request for an appeal through your claimant portal. There's a menu where you can upload your own documents. You should also provide any documents you have to support your reason for the appeal. You should also email your request for an appeal to appeals.due@due.sc.gov. You can fax it to the Department of Employment and Workforce also, and then mail it directly to them. If you do all of those things, they're absolutely likely to find your appeal. The best way to request an appeal is to upload that notice of appeal or request for appeal through your claimant portal. So that's not the only time that you should appeal. Of course, you should appeal if you're found ineligible for benefits. You should also appeal if you think there's something wrong with the wages that due has recorded for you. So you may be getting a lower amount of weekly benefit because the wages are incorrect, because maybe your employer mistakenly didn't report all your wages, or maybe you were misclassified as an independent contractor, but you're really an employee, in which case you would be eligible for unemployment insurance benefits. You were paid cash as an independent contractor, but you fit the definition of an employee. So that's misclassification. So even if your employer classifies you as an independent contractor, you can still be an employee. And that's determined under South Carolina law. And those factors are who has the right to exercise control over you? Who tells you when to come in and when to leave? Do they set your hours? Do they have the right to fire you? How how are you paid? If you're paid through a paycheck, through like everyone else through regular payroll, then of course you're an employee even though you're classified. You may be an employee even though you're classified as an independent contractor. Do you bring your own equipment? So are you working in a restaurant and you're a line cook and you use their knives and you use their fryer and you use their stove? You're not bringing any of those things with you. So things like that. So those are those are when you should appeal your determination of benefits. Because if your employer responds to you and says that you're an independent contractor, but you've been working for an hourly wage for the last year, and they've been telling you when to come in and when to leave, and you've been using their equipment to do your job, then you're not really an independent contractor. You're not working for yourself. You're working for someone else, and they should be responsible for paying unemployment insurance benefits. So I'll go ahead. This seems like a good time to go through the appeals.
There are a couple of other questions which you may be getting ready to answer, and if that's the case, you can say so. One of the questions, these are both about the appeals.
Okay.
One is an appeal based on a COVID loss of employment required?
Yes, I mean, okay, so maybe the best lawyer answer ever. So I guess this is how I'm understanding the question, is that you've applied for unemployment insurance benefits stating that you lost your job as a result of COVID-19. At some point, the employer responded back that that's not why. So the department has denied benefits, but you're insisting that it is COVID related, then yes, you should appeal and then provide documentation or information about why it was COVID related. However, I will say this. So if you're talking about regular unemployment insurance benefits, then, and your hours were cut, or your employer, closed up shop or laid you off because of COVID-19, then that's an appeal of UI related to COVID-19. Now, if you fall into one of the other categories, like you're unable to attend work because you have an underlying medical condition that makes you more susceptible to COVID-19, so you're not able to go to work, then that's not a regular unemployment insurance benefit claim, that's a PUA claim, because unemployment insurance benefits requires that you be able to work. And because you have this underlying condition and because of the pandemic, you are not able to work. So you are, by definition, not eligible for UI benefits. However, you are eligible for pandemic unemployment assistance.
Okay. What should claimants do if they have received a letter informing that they are eligible but have not yet received a payment for a pending issue? It has been 5 weeks, and pending issue is in quotation marks. It has been 5 weeks since the claimant received the letter stating they are eligible for benefits. So how long does it, would it take for something like that?
So usually when we're not in a global pandemic, it takes about 21 days. Right now, I'm seeing some of the same things with my clients as well, that it's taking, 5 to 8 weeks. My suggestion would be to either maybe do an intake with South Carolina Legal Services to see if there's something that needs to be resolved. You can also attempt to get on the phone with unemployment to see what the issue is and provide them with whatever additional information they need to get your claim processed. I've also seen issues with debit cards that are being sent out. I had some clients that didn't receive the debit card and had to request a new one. So it can be a variety of issues. The major problem is that there have been so many claims filed in the last couple of months that it's just the system has slowed down quite a bit.
Okay, and one last question on that, probably that same note. If you lost your job due to COVID because the workplace closed and waited a long time to file and got immediately denied, what can be done about that, particularly where you did put on your claim for UIB that the layoff was due to COVID?
So it depends on what you should appeal the denial. Whenever you're denied, my advice is always to appeal, just because sometimes things are missed. And the reason for the denial should be in that determination. And it could be because they've determined that you weren't an employee and maybe you needed to apply for PUA, or you didn't make enough in the last 5 quarters to qualify for unemployment insurance benefits. So the short answer is appeal, and then get all your documentation together showing that you were an employee, and that you did make enough to present to the hearing officer for your telephone hearing. And then also you apply for PUA, pandemic unemployment assistance also.
What if they hadn't been working long enough to qualify, or didn't have enough work time to qualify?
So I would say apply for PUA and appeal.
Okay, looks like that's all the questions for right now. I'll let you continue.
Okay, so I'll just review the appeals process really quickly. Okay, so once you file your claim, there's an initial determination that's made. Someone from the Department of Employment and Workforce contacts you, asks you a bunch of questions, or they send you a form for you to fill out. And they also contact your employer to verify that you were working there, that you were an employee, and that the reason for the termination is as you say it is, okay? If you receive an initial determination and you're denied, you need to appeal within 10 days of the mailing date that's on the determination. And when you appeal, that's appealed to what's called the appeal tribunal. And that is, you will have a hearing with a hearing officer over the phone to state your case of why you should be eligible for unemployment insurance benefits. It's a relatively informal hearing. The individual or the side that's appealing gets to speak first, and then the other side has the option of responding. All right, so if you apply to the appeal tribunal and the hearing officer issues a decision against you saying that you're still not eligible for benefits, then the next step is to appeal to the appellate panel. Now, I will say this, that the appeal tribunal stage, that hearing, is your only opportunity to submit evidence on the record, okay? So if you have text messages, emails, pay stubs, a termination letter, any kind of documentation, or if you have witnesses that can testify on your behalf, that's your only opportunity to get that information to the Department of Employment and Workforce. So it's very, very important that you have all of that information entered into evidence during that informal hearing. Now, The appellate panel is a panel of 3 judges, and they conduct a de novo review, which means that the decision of the hearing officer does not affect their decision. However, their decision is based on whatever evidence and testimony was presented at that hearing over the phone. You cannot submit new evidence for an appellate panel review. These are usually done without a hearing. So you request the appellate panel review, the 3 judges get together, they review the record, and they issue a decision just based on the record. If you want an in-person hearing, then you have to specifically request one. And if you get one, you will go to Columbia, to the main building, and actually they're probably doing it remotely now, but you get 10 minutes to state your case, the other side gets 10 minutes to respond, and you get a little bit of rebuttal time. And then they review your arguments and the evidence submitted at the hearing, and then make a decision. Now, if they also decide against you at that point, you can appeal to the administrative law court. And if you're at that point, I would suggest looking for an attorney to assist you with filing that, because it requires briefs and some fairly complicated legal documents, or at least get some assistance with understanding them. So that's the appeal process. The most important part, of course, is the telephone hearing. So just be prepared and have all your documents into the department within at least 24 hours before the hearing. You can email them, fax them, or mail them. Okay, so how to appeal. Appeals need to be requested within 10 days of the mailing date on the determination letter. They stick to this pretty hard. If for some reason you don't receive the letter in time, then sometimes you can request a review to get a hearing set, but you have to have some reason that you didn't receive the letter. So some good reasons would be, you were hospitalized, or you didn't have access to the internet or your mail because you had to vacate your home for a period of time because of, I've seen this for a hurricane, I've seen the hospitalization, you moved and your mail wasn't forwarded or something of that nature. There needs to be some reason why you didn't appeal within the allotted time. Okay, so you can file an appeal using the Notice of Appeal to the Appeal Tribunal form, which is located on DU's website at this link. You can write an appeal letter detailing your disagreement with the determination. You need to include your name and social security number. There's also a button under the determination page on your claimant portal that just says appeal, and you can click that button and go through the process of appealing that way as well. You should upload your appeal through the claimant portal. That's the fastest way and the most effective way to request your appeal, because then you know the department got it. I do it all sorts of ways. So I upload my appeal through my client's portal. I fax the appeal to DU at this number, 803-737-0287, and I also email it to them at appealshelp@du.sc.gov, and I mail it to them at their mailing address listed here, just to make sure that they got it. Okay, so here's some common issues that we've been seeing. And I just wanted to go through them with you. Maybe you guys are having the same kind of issue, and it'll give you some answers as to what you should do. So you cannot apply for benefits at all. So I've had some issues. I had some clients say that the department just won't let them apply, either because they're saying that they maybe they're saying that you need to apply in a different state. You can't apply here in South Carolina. You can't log on to the benefits portal to file a claim. They have notice of an overpayment that you haven't paid back yet, so they're just not letting you apply for a new claim. If this happens to you, you should seek assistance from an attorney and file a written appeal with due, just to fight the denial of application. I've also seen some issues with claimants being able to log into the portal. So sometimes I'll have clients that have previously received unemployment insurance benefits, and now they're applying for a new claim. So they already have a login and password with the department. So it's important that you remember that login and password. You can request a new password, but you need to have access to whatever email you originally submitted as your contact information for due. I've seen this a couple of times, which is kind of interesting. I've had clients that had an unemployment claim a few years ago. They went through the process. They got married, and now their name has changed, and they're trying to log in and file a claim, but the portal won't let you. And the reason is because you're going to have to file your claim under your maiden name and then submit notification to due that your name has changed. So those are just some interesting things that I've seen the last 3 or 4 months that I like to share, just because it's usually an easy fix. Okay, so in some instances, individuals will receive benefits that they weren't entitled to. So they're receiving benefits, they started working, the department didn't stop their benefits quickly enough, and they received an overpayment. Or they were initially approved for unemployment insurance benefits during an initial determination, but then the employer appealed that determination, and there was a telephone hearing that was held, and the hearing officer determined that the claimant was not entitled to benefits. So the claimant will receive benefits up until the decision of the hearing officer. So you could get up to 4 or 5 weeks of benefits, sometimes 6 or 7. And if you're determined to be not eligible for benefits after that hearing, then you have to pay those benefits back. So if the overpayment is classified as non-fraudulent, that means that you didn't mislead the department or lie or something of that nature, then your benefits will be seized until your overpayment is repaid. So that means, number one, the department cannot keep you from applying for benefits because of a non-fraudulent overpayment. And once you're approved for benefits, then your benefits will be seized until your overpayment is repaid. Now, if the overpayment was classified as fraudulent, meaning that you reported to the department that you were not working when you were working and receiving income, then that's just an example of a fraudulent overpayment. Then you can be disqualified from receiving benefits for between 10 and 52 weeks. And you'll also be responsible for a 25% penalty fee that will be added to what's to be repaid to the Department of Employment and Workforce. Okay. So you were paid severance pay, so you don't think that you are eligible for benefits. Well, that's not true. In South Carolina, severance pay is classified as income paid for work previously done. So it is not counted as income after the employment ended to reduce your amount of unemployment benefits. So whether or not you receive severance pay should not be taken into consideration as far as whether or not you're eligible to receive benefits. Now, I will say that you need to be careful about you sign a severance agreement, what's in that severance agreement and what you've agreed to do in there. That can be an issue. And if you do have an issue like that, then you should seek the assistance of an attorney to assist you with unemployment benefits. You've been furloughed because of COVID-19, but you are still receiving payments. Okay, so I wanted to I've had some clients get confused about what the difference between being furloughed and being laid off is. So when a person is furloughed, they're still technically employed by their employer. However, they're not working right now because either there's not enough work or the business is closed, or they're not running the factory right now. Now, the benefit of being furloughed is that furloughed employees are still eligible to receive other benefits, such as health insurance and disability insurance and things like that. And that is the reason that employers furlough employees instead of terminating them or laying them off. So being laid off means that your employment has ended. You have separated from your employer, and they can or cannot bring you back when they reopen. Okay, that means that also your any benefits that you received through that employer have also stopped. Now, because of COVID-19, I know some employers have tried to are attempting to make payments to employees that have been furloughed. And if they are making payments under normal circumstances, if you're receiving ongoing income, that would be counted against you during for your benefit amount. So like it would be if you were working part-time, your benefits would be reduced. However, because of an executive order, any payments made to furloughed employees after they've stopped working are going to be classified as severance pay and will not prevent you from being eligible to receive unemployment benefits. Now, what does need to happen is your employer needs to notify the Department of Employment and Workforce that they're going to be making these payments, and they can do that. There's a link on there for employers to do that as well. Okay. So you're found to be eligible for zero benefits, even though claimant has sufficient earnings. All right, so number one, you need to file an appeal and request a wage investigation. And that's a form that the department has. However, I will say that it is not a form that is made available to the public all the time in their forms menu. So you would need to contact and request that form from a person at the department, which means that you're going to need to get on the phone and contact you and go through the process of getting a representative on the phone to talk to about that. Now, you're also going to need to, when you request a wage investigation, you will also have to present evidence to do that you did in fact earn sufficient wages. So you need to be gathering that evidence as well. So tax returns, check stubs, your W-2, employer letters, text messages, 1099, anything you have showing that you earned income. Okay, so the department, unemployment benefits can be difficult to navigate during COVID-19. And legal services is, trying to assist claimants with that process. And if you would like to apply for our services, you can call our intake office at 888-346-5592, or you can apply online at https://sclegal.org. Now, if you have been served with court papers or have a deadline, like a deadline to appeal your denial of unemployment benefits, you can contact your local legal services office to do an intake on an emergency basis. And those are the contact for our local offices is also available at sclegal.org. Susie, do we have any other questions?
I do not see any other questions in the box for questions. So with that, if that's is this your last slide? I believe it is.
I think it is.
Okay. Well, let me.
Contact information.
Oh, there we go. Yeah. So I want to just thank Stephanie and Horst, our Employment Law Unit Head for South Carolina Legal Services, for an excellent presentation. You have definitely leveled up our legal knowledge on navigating the unemployment benefits during COVID-19 for sure. And I just want to also mention that Legal Services does have an online classroom that provides similar and additional information on unemployment benefit appeals in South Carolina. And you can access that through our lawhelp.org website. It's lawhelp, LAWHELP.org/SC for that and other classrooms about other legal matters. We will continue to host the Level Up Law series on Tuesdays at noon, and look forward to June 23rd when Mark Fetchler will be talking about Rent Smart, basic landlord and tenant rights in South Carolina. And June 30th, Tuesday at noon, Taylor Ott will be making a presentation on Keep It Simple, Elder Law 101. And finally, Tiffany Love, our lead barriers to employment attorney, will be presenting on removing barriers to employment on July 7th. That's also a Tuesday at noon. And we welcome all of you to register for those. And again, I want to thank Stephanie for a wonderful presentation. And that concludes our webinar for today. Thanks for listening, everyone.